So I'll pick up from where Adrian left his initial intervention, which was, well, efficiencies are a good thing. I'm so moved and sentimental that I get to speak right after this kind of a remark, because that never happens. It's always that I'm a bit of a lone soldier in trying to advance the point that while innovation is mystical in a sense and is very difficult to calculate, its mystical nature is leading to a paradox more and more, which is that when the agencies are using it as a source of concern, they see things as very articulable and calculable, whereas when Defense Counsel is putting forward matters belonging to innovation, it is seen as, meh, you're talking about synergies and other soft things. This is not going to redeem the concrete issues that we have at hand. This inability to be used as a shield, but tremendous ability to be used as a sword, is actually leading to a type of paradox. But before getting into that, maybe, let's take half a step back and position ourselves. Why is this so important? Where are we in the track record of things in the innovation theories of harm? Why is this so important? May start with the definition of innovation. Let me read to you a quick one that I concocted from different definitions of it. Innovation basically is the setting up of a new production function leading to inventions or developments of new products or services or improvements on them, or triggering cultural transformations through introductions of new ways of use of such products and services, or triggering establishment of new industries through such new approaches. Why did I read something to you? Because this being the gist of innovation, it actually has a function that is far superior to allocative efficiencies or distributive efficiencies in one hand, or cost efficiencies in its potential to advance welfare for human beings. The fact that it's mystical doesn't take away that property. I'm not saying allocative efficiencies aren't important. In fact, if anything, we being competition lawyers, we're putting a lot of emphasis on allocative, i.e. distributive efficiencies. We're focusing on price a lot, and most of our understanding of efficiencies is happening in the distributive efficiency sphere. Cost efficiencies we're always doubtful about, because is it being passed on to the consumer or is it not being passed on to the consumer? Are we going to follow consumer welfare function, or are we going to follow a total welfare, i.e. social welfare function? So there's a bit of debate there. And then there's this whole other cylinder of innovation and innovative efficiencies, i.e. dynamic efficiencies. Now, why would this be so important for welfare? Because so far no one has actually proven that Malthus was wrong, i.e. food and other welfare parameters were going to multiply in arithmetical order, and population was going to multiply in geometrical order, and there were going to be wars for food, and we were going to all starve. I'm not saying starving or hunger is not a problem in the world at the moment, but what Malthus predicted didn't happen either. And the sole reason why it didn't happen is innovation and advancements in technology. It's that important. Now, if it is that important, and if competition law is so directly linked to the protection of innovation, we need to get this one right. And we need to get it right quickly, in the sense that we should move away from scaremongering, and we should make sure that we are basing our analysis on solid facts, the way it is mandated by case law as well. In Tetra Laval versus Commission in 2005, you would see the burden on the Commission being factually accurate, reliable, and consistent, and the evidence body should be that way too, and that's good case law still. Now, how are we going to apply Tetra Laval versus Commission to the innovation sphere is the question we're discussing today. To be able to do that, we need to look into the track record of things and how things developed in the innovation sphere. We can see a lot of cases all in merger control. A lot of cases that ended with commitments that had to do with innovation. Bayer Aventis ended with commitments because there were innovation worries. Syngenta, Monsanto, Sunflower, Western Digital, Viviti, Medtronic, Covidien, Pfizer, Hospira, Dow DuPont, these all led to commitments. In fact, in Dow DuPont, it was the entire R&D division globally that was being divested. So it's a huge move in terms of its innovation effect as well. And if you were to look into the grassroots of all of this, you would go back to 1996, basically, where in the Ciba Sandoz case, there was the first recognition of a separate characteristics of innovation markets. You see that finally in 96, someone says there is something as innovation markets. So we're only talking about 27 years of development of something. Before that, innovation was not in our lives in that sense. There was a lot of doctrine on dynamic efficiencies being a thing, but it wasn't in the merger control sphere and definitely not as something recognized by the enforcers. Then you see Medtronic Covidien in 2014, the first significant reliance on internal documents as a source of evidence, which is something that we're discussing a lot now. Should we be relying on internal evidence as much as we do? Should we not be doing this much of probative value on internal documents? This comes in from Medtronic Covidien of 10 years ago only. In Novartis GSK in 2015, you have seen the first time articulation of pipeline concerns before phase 3. You have seen the first use of effects on competition in innovation without a particular product. So in Novartis, you have seen that innovation markets are defined so independently that I'm not even focusing sometimes on product markets. Then you have seen the vocabulary for the first time, innovation spaces in Deutsche Börse versus Commission in 2015. In Dow DuPont, you have seen a test, significant impediment to effective innovation competition, and the discovery stages were also focused on. We're not talking about advanced innovation about to hit the market kind of product, but we're talking about the discovery phases as well. I'm not going to bore you with these, but these are things that I have selected for you to show you the journey. And then in Bayer Monsanto, you have seen an emphasis on cannibalization, so much so that you kind of started to feel maybe the enforcers are going to feel that certain effects dominate all the others. And if there is cannibalization, then they're going to check out from the analysis. Cannibalization basically being the potential of two competitors to take sales from each other if they're moving in the same innovation spheres. So negative externalities, basically, that they exercise on each other. And then the famous Illumina Grail came in. And with Illumina Grail, we all have recognized that this ballgame is a different one now, and innovation theories of harm are going to become the next big thing in providing uncertainty for legal counsel, including in-house, and also in making sure that we get this one right, because there's not a scale element to it either, as it was an Article 22 kind of a matter, meaning the Commission said, I am making this my business. It didn't need to be notified to the Commission, but the Commission said, well, I'm using Article 22 to make it my business. And this is obviously an unforeseeability kind of an issue as well. And in Illumina Grail, we have for the first time also seen the following. The enforcer said, this is very complicated, the remedy proposal. I just, on account of it being complicated, on account of it being difficult to monitor, I'm checking out. Now that's an interesting thing that we should start discussing, especially in view of Microsoft Activision now. Because in Microsoft Activision, we're in this delicious moment in time where one very prominent antitrust agency, being the CMA in the UK, said this is too complicated and it won't do to a set of remedies, where the EU Commission said, for the same set of remedies, good enough, I'll allow it. The articulation of theories of harm was the same. I'm going to get to whether the Microsoft Activision should be, a case should be characterized as an innovation theories of harm kind of case. In my view, it shouldn't be. And this is showing another risk of this matter, which is that sometimes there's just lip service to innovation theories of harm in support of other actual, more traditional concerns existing in the file. In Microsoft Activision, this was traditional vertical worries, basically. But when it came to articulating the worries, suddenly innovation theories of harm were being advanced in certain paragraphs of the decision of the CMA as well, which should not happen, because if you were to give a supportive role to innovation theories of harm, then you're going to lose your grip on actual articulation of what is an innovation theory of harm. So only if sincerely you are concerned about innovation theories of harm, then you should pursue it, but it's not a nice to have in a case where you're very convinced that there are unilateral conduct, unilateral issues, or a case where the traditional vertical issues are being displayed, such as Microsoft Activision. So in Illumina Grail, basically, we have seen that the remedy proposals are challenging and that the authority is not happy to address the complexity of what is proposed, whereas the EU found it to be a-okay. Where does this whole journey leave us? It leaves us at a point where we need to recognize a few things. Do I have 3-4 minutes more? Yeah. So, because this is the crescendo of it, I wouldn't want to. I'm building up to this moment.
Go ahead.
Then the premise, I think, is that we should first look into whether mergers are an optional privilege, something that we can all do without in the innovation spheres. So, if we don't allow it, no big deal. If we allow it, it's a privilege being exercised, kind of a balance? Or is it that in the innovation sphere and in the innovation-intensive markets, you actually do need mergers to happen? So each time you flag an issue and each time you bring down a transaction, you should be careful. That's a policy preference. I would say that my tendency is toward giving deference to the virtues of a merger. It doesn't mean you should allow anything and everything that comes in, but it does mean that you should be very careful in how you place the burden of proof and how you exercise the standard of proof. So there is an inherent dynamism and a still elusive nature of innovation, and that does not sit well with the ex ante nature of merger control. This is the issue that we're looking at. There is a degree of speculation that is inevitable when you're articulating in merger control and innovation theory of harm. And the way to distinguish between speculative scaremongering and actual articulation of a theory of harm is by way of making sure that there's a holistic analysis taking into account all parameters that need to be taken into account. So there should be no economic or legal presumption available that goes in the way of reduction of innovation. The first thing that we, I think, should agree on is that any economic or legal presumption about the reduction of innovation by mergers in terms of innovation is to be discarded, and there should be a separate element of proof in each case. There has to be a complex case-specific analysis that balances market structure elements and factors of innovation incentives and innovation capacity, and it should focus on economic data and specific facts. At the moment, there is another disparity, that is, when general economic theory is relied on by enforcement agencies, it can be done, whereas it is not easy to do this for the Defense Council as well. All this leads to the supportive role that I have told you about, asymmetries in proof that I have told you about, and the exclusion of cost efficiencies relating to innovation from the analysis altogether. Innovation does bring in cost efficiencies, but we're not able to focus on it as much as we would, because basically the presumptions are getting into gameplay very quickly. So we need a neutral starting point. We need neither an Arrowian nor a Schumpeterian kind of an approach in these things, and no quick shift of burden of proof. And even the arrow predictions should not be used, in my view, in the sense that the agencies should show that the arrow predictions do indeed apply in the specific case at hand, and it's not the word of God in terms of the given case to us, which can only be done with this holistic review of the entire market parameters. And we should recognize that the applying parties cannot, even if they wanted to, they cannot put forward the holistic view of the market in its entirety, because they only have data relating to themselves, the two transaction parties. So there's homework to be done by the agencies without quickly shifting the burden of proof on the parties if an innovation query is being articulated, because if they do it too quickly, then the parties may not be able to prove issues that belong to the entirety of the market for lack of information in their own hands. And there should be no dispositive reliance on general economic literature or over-reliance on internal company correspondences, in my view. One could say, as Ioannis would say, well, I mean, if I have all these correspondences, what do I do with it? I'm an enforcer, and if I see it, I'll use it. I'm not saying we should not rely on them at all, but I think we should also give some deference to general corporate boasting, and that anything in the correspondence isn't directly proving its content. It is corroborating evidence, it is an indicia, but it can be negated in terms of the future company plans or in terms of the dynamics of the market with economic data.
But, thank you, Gönenç, but one might say, that's why you can reverse the burden of proof there. You made your prima facie case, you have these internal documents, and then it's on the company to show, well, that's not really what happened, but these documents are saying, which of course, is something that you usually don't do, because at that level, basically the game is lost. But I think it's a very interesting presentation, and it reminded me of Niels Bohr's comment that prediction is very difficult, especially if it's about the future. And of course, that's the case. Now, you raise, I think, 4 different instances where innovation theories of harm may come in. The first one is where to define the field of competition, like the market definition, what is a space, field, market, where things are happening. And I think it's pretty clear, and we more or less know it, that the price dimension now may not capture the substitution between products, and therefore we need to focus on performance and dimensions, of course, in order to determine what is a space where competition is actually held. And there have been a lot of ideas about innovation markets as a concept, future markets as another concept, innovation spaces. And of course, one might say you can have different approaches. Things are easy when you have directed research. So basically, that there is a specific product out of the pipeline. You can somehow, be able to apply the traditional market definition tool. Things are a bit more difficult, and this is what the actual chief economist of the European Commission mentioned in a paper with Pierre Regibo, a paper with Cathy Rocket. Undirected research is more difficult, and what is undirected research is situations where the applicability of innovation efforts is not necessarily known ex ante, and the nature of such research activity may indicate the use of alternative market definition methods. So this is, I think, where most of the issues come in at this level. Then secondly, the theories of harm issue that you mentioned before. I mean, what type of effect on innovation we might have. We can, somehow find ourselves some theoretical perspectives on modeling, either, taking the Arovian, perspective or taking the Schumpeterian one. But again, in terms of measures, of innovation, I mean, we can also measure innovation. I mean, there have been different suggestions, inputs into the innovation process. For instance, the percentage of the firm's capital invested in innovation, which could, be an indication of is really going on a lot of innovation here. Secondly, it can be intermediate outputs, such as patents, for instance, that could, also indicate the idea that there is innovation. Thirdly, outcome metrics, which could be, the level and observable new competences that are required as a result of this R&D investment. And I think maybe a lot of work needs to be done at that level in order to help us to not necessarily only focus on internal documents and abstract theories of harm, but also, maybe move to more effects analysis. However, I have to say, the burden should be, the commission or the competition authority should make a prima facie case, and then it will be a reversal of the burden of proof on the parties, or the evidential burden of proof of the parties, to claim that, there are no effects, for instance. Thirdly, the innovation come out also with the efficiencies, and now we haven't heard much about that. But maybe you would like to comment, or some others would like to comment on how, innovation can be a valid story of efficiencies. I mean, how you can build that. In particular, if you have, from the other side, anti-competitive effects, unilateral possible price increases. I mean, how you can come with a innovation story to somehow make this less problematic for your case. And the fourth aspect you mentioned was the remedies issue, which is more difficult. And here I have to say, when I haven't read the Microsoft Activision, I printed it, it's there, it's 400 pages long, and I'm waiting at some point to read it, so, hopefully in the next few days. But I read the summary that very helpfully the CMA published, and again, and then, it wasn't that, it doesn't seem to me that they arrived so easily to the result. They distinguish the console gaming, where they say, well, we haven't been convinced there. And they move to the cloud gaming, and they say that, look, we found, I read, that Activision's games are likely to be important to cloud gaming services in the future. And while Activision has so far not offered its games on a cloud gaming service, the evidence shows, and they have quite a significant amount of evidence, I cannot really obviously make the assessment, that it will have strong incentives to do so, particularly given the significant growth projections for cloud gaming. We concluded, therefore, that without the merger, Activision games will become available on cloud gaming services in the UK in the near future. So it's basically about a guess concerning the possible, future entry of Activision in this space, which is not an abstract guess. It's an educated guess on the basis of a number of documents and the assessment that the competition authority made of it. Will you have a problem with that type of analysis? Of course, as Niels Bohr said, with prediction, it's difficult about the future. We cannot really, request levels of certainty. We're in a game of prediction, after all. But what this type of assessment might be of interest. And the other thing I wanted to say is, yes, of course, I understand that. Your point about merger is something that it's a possible way to enhance innovation. Organic growth is not the only way, etc. But I'm quite troubled by recent research. For instance, there's a very recent paper published by culminating kind of work that they've done by Florian Ederer and Bruno Pellegrino at the American Economic Association Papers and Proceedings, where they say, well, there has been a secular shift, I quote, from IPOs to acquisitions of venture capital-backed startups, and show that this trend is accompanied by an increase in the opportunity cost of going public over the last quarter century. Dominant companies that are disproportionately active in the corporate control market for startups have become more insulated from the pressures of product market competition of the same period. So basically saying that we move from IPOs to basically mergers as a way for the startups to build up size, etc. And this leads to less dynamism in the market and more prevalence of the dominant corporations that we know now for the last 20, 30 years in the future, and that creates some issues concerning innovation. So I would like some comments on that, not only from Gönenç, but also from the other speakers. Yeah. So maybe Gönenç first.
Yeah, sure. Thank you. This is very, very interesting, and I do agree actually with a surprisingly high amount of what you have said in the sense that it does look like it's negating what I'm saying, but these should live together at some level. So one by one, I'd say with Florian and Bruno's work, it is interesting. It seems to me, and I'm speaking at a panel where there are economists as well, while economy does happen to be a science, there is a lot of, this is black, no, this is white, kind of work coming up. It's not a surprise when lawyers do it because it's an argumentative field and it's not a science, but it does come in quite a bit in economics. And Florian and Bruno's work is in the line of Federico and Valetti's work as well. So what I was saying, Federico and Valetti also say that the negative impact of cannibalization effect on innovation incentives will dominate anything and everything. And this is a very interesting study. I've looked into it before, and there is something there. So exactly, as I said, the endogenous growth is important in dealing with innovation issues, but exogenous growth should not be discounted altogether, is what I am trying to say. In terms of the futuristic guesses that are happening in this sphere, it's inevitable. I'm not attacking the fact that there will have to be some degree of projections into the future. But for example, the example Ioannis is using for Microsoft Activision is a problem for me. Not because it's a prediction into the future, but that very prediction needs a lot of more substantiation because it's actually in the root of the entire analysis. So it begs the following question. Activision has not made that move until year 2023. And now you're predicting as an antitrust agency, which is not equipped to come up with these kinds of business decisions, so you should feel tentative already, that in the next 4 or 5 years, it would have done that move. So why did it not do it until 2023, and why do you think imminently they would do it without the existence of the merger? I would need a lot more language in there, and while we have 400 pages of the document, and I have read it, there's nothing there in that, So these are, and because they're not feeling under the pressure of justifying that bit as much as one would hope for. It's a good decision. I'm not saying it's not a well-studied decision. I do agree with Ioannis that a lot of effort has gone in there, but it's not that difficult to leave alone the console side of it. I'm not going to give them the credit of being balanced just because they said on the consoles bit, I'm not seeing a problem. On the cloud bit, I'm seeing a problem. Of course, on the consoles bit, you don't see a problem because if they were to do exclusivity in the consoles for these kinds of games, Call of Duty particularly, then they're going to lose money, and it's too obvious. So on the basis of that, you leave alone the consoles bit, and it's a traditional vertical worry kind of articulation anyway, so it doesn't interest me as much. But when you go into the cloud bit, you're looking at a nascent market, a market that is super dynamic and very, very new. So any theory of harm that you're going to develop will necessarily, and this is the critical sentence I would like to come up with, will necessarily have to be countered with some complex remedification, and it's not going to be very convenient, is what I am trying to say. On account of it being complex, it should not have been discarded. One last sentence, really last sentence, on efficiencies and innovation. I would only give the following slogan, that is, cost efficiencies stemming out of innovation are underrated at the moment, in my view, and process innovation is underrated as opposed to product innovation at the moment. So too much emphasis on product innovation, not enough emphasis on process innovation, in my view. Just one final sentence on standard of proof matter, because we've gone into it, and in the same spirit of leaving the audience with some slogans at least to look into. Process innovation should be also an issue, I said, and cost efficiencies resulting from innovation aren't being explored as much as they should be, I said. Another issue is, in the standard of proof vein, is that the earlier the stage of innovation that is presumably being protected, the higher the standard of proof should be, which is not what we're observing at the moment. Because especially the burden of checking whether the underlying assumptions of certain economic literature really applies to the case at hand. So throwing general economic literature at very early stage innovation is also a mismatch in my view. And on the issue of remedies, the traditional measures addressing unilateral effects are being used at the moment in handling innovation worries as well. We will have to start articulating more complex sets of remedies, and the competition agencies, I think, will have to come to terms with the idea that in the innovation theories of harm sphere, addressing concerns won't come as a boilerplate as it is in the unilateral effects territory.
Simon Holmes, wearing my Oxford hat, I think, here, rather than the cat hat. I think it's what you call a two-sided question. It's I'm a great fan of efficiency and innovation, but this is a mergers conference, and I certainly see a disconnect between the mantra that mergers are from the big business and so forth, the mantra that mergers are a good thing and good for innovation and so forth, a disconnect between that and the fundamental starting point that you're, in a case of a horizontal merger, as Adrian pointed out, you're talking about two firms no longer competing. And although there's less evidence than there should be, than one would like to see, the academic evidence, which points strongly in favour of there being the supposed benefits of mergers rarely materialising. One could talk about Groningen, Pearce, Concurrences, and so forth. And the other part of that question is the idea that there's an asymmetry in terms of the burden of proof. I find difficult to reconcile with the stats on the low level of intervention and the low level of deals being blocked. If it's less than 1% are blocked to the EU level, if the burden was different, if the asymmetry was different, are we talking about 99.9% being approved? Perhaps that's what many in the city would like, though.
So the first point, basically, if Simon allows me to reformulate it, but I will look for a nod, what does scale have to do with it is the question, no? Because you're saying this is a merger conference, and in innovation, why does a merger in and of itself bring a virtue? And that question can be translated into scale. What is it for innovation? And my response would be that scale would help if there is contestability, obviously. So I'm not disputing what Adrian said, which is if you're merging into a monopoly, we're not discussing anything. But scale does help if there is contestability in the market with appropriability, which is very important to further innovation, and with synergies. So appropriability, I would say, is the ability of an innovator to benefit from its investments. And scale helps with appropriability and with cost efficiencies of innovation as well, because it's difficult to engage in rapid imitation if there is scale. So if there are incentives to innovate, scale does feed that incentive in fostering appropriability. But whether appropriability can be a good countervailing factor to cannibalization kind of worries is a discussion. Some say, like Valetti and Federico, and also Valetti in another paper, that whenever there is cannibalization effect, that's going to dominate, so don't come to me with appropriability. I don't agree with that position. And the other is the synergies, which is the extent to which combining complementary assets will produce incentives to increase innovation. And complementary assets coming together can happen exogenously through mergers. And that's why we shouldn't discount the virtue of mergers. But I should, again, calibrate what I'm saying. I'm not saying it's so intrinsically valuable that we should be deferring to all mergers. I'm saying this balance is a very sensitive balance, which brings me to the second point you made. And I should say I'm unable to speak in terms of percentages because I would have to look at every single case in its own dynamics. And when I see some cases that aren't going through with enough explanation as to what exactly is the innovation concern, and with a lack of commitment to the remedy proposals, I do want to flag that there may have been a way here, but the agencies are not hungry enough to go into the uncharted territories, whereas we're not going to be in our comfort zone if we want to make the merger live. And do we want to make the merger live? Do we believe in the appropriability and the synergies part of it? Or are we really contending ourselves in, I'm already having unilateral effects concerns or vertical concerns, so I'm going to combine it with innovation concerns, and this fudge is going to do it.